Hi, this is Dr. John Grazel, and this presentation is on the role of law and international development and international assistance. And it's very vital to say that from the very beginning, actually, law was something that people always looked to as changing societies, even before World War II, when you got modernization in Japan. You got the rewritten Japanese constitution, greatly influenced by German law, for instance. So law has long been seen as a vehicle for social transformation. Uh, and therefore, at the beginning, right after World War II, was one of the vehicles as you did write new constitutions for Japan, and as you created new codes and new rules. And there was a belief that the legal institutions of modern Western economic society were also critical in order to create economic modernization in undeveloped countries. The legal process actually is much more complex. That law is not just the laws of the books. Laws are a system. Laws are institution. There have to be police. There have to be courts. There has to be a legislature. There has to be means of publicizing the law. And there has to be a general understanding of mutuality between those who make the laws and those for whom the laws apply as to what the very purpose of law is. And this brings to the fact that very often people skip over that and they just think law is a solution to a particular problem: corruption, how we invest money, how we address human rights, how we decide who controls resources. And that somehow, just by writing a law, you could begin a process of major transformation, which does not prove true in the majority of cases unless it corresponds to other actions that are occurring at the time. And even to the extent that it does provide a very important new element, the question of access to it and equitable access to that itself can determine whether that law actually solves the problem or in some cases actually makes it worse. Now, behind this all is the thing that we live in an international order of different cultures and nations, and we have what's called conflict of laws. Traditionally, law is the law of nations. And the laws we have, whether we're talking about modern nations or traditional nations, whether we're talking about secular nations or whether we're talking about religious communities, is the law of those communities or nations. And conflict of law is actually traditionally a field of how each of those communities deal with the fact that sometimes there's a conflict between their laws and another law. It's not one field. It's about how each separate group deals with it. So how does the United States deal with the fact that polygamy is illegal, but people come over from countries where it's not illegal and they immigrate and they already have 4 wives? That's a decision of the American legal system, not of a larger international legal system. And in that sense, immediately gets us into the fact that law actually serves very often as an expression of accepted practices, accepted values, and accepted expectations. And this is where we get a bit of a chicken and egg between those who see law as a way of changing practices, values, expectations, and those who see it as a way of preserving and protecting practices, values, and expectations. And in this sense, you have a third element, which is not the Western tradition, but the non-Western tradition. The Western tradition tends to see law as a formative process. It determines sort of what are the standards, and then it adjudicates when there are conflicts. But there is a whole other aspect of looking at law that was in many Asian countries, certainly was in the Soviet Union, which actually saw law as a process by which you reaffirm the decision of those in power of what was going to be accepted. You actually didn't go through a judicial process to determine, but it was more a case, literally, of moral theater. The Soviet the Stalin trials, purge trials, are a wonderful example of this. But it existed across the spectrum, and in many other countries where law actually serves to be a drama that presents what people want to be the decision, not to decide what the decision is. And then there's actually a third element of law that you find in many traditional societies, where actually it's a forum of negotiation and arbitration. And the real purpose is not seen as either announcing a pre-existing decision or determining, but recreating and building harmony. Given all these factors, we now live in a different world. We do live in a world where there is now beginning to be more and more international law, international agreements, international mechanisms such as the World Court. And we're seeing a tension now between different national laws, different communities, as there's migration into countries has increased. So you actually have groups from one country trying to establish, for instance, their religious law in another country, and then a tension between true international law as a single entity and the law of different nations and how they relate to each other internationally. Now, one way this can be handled, or another way this can be looked at, is to realize that in this period of transformation, what's really key is realizing that law can be a constituting process, that making the very decisions as to how we want our legal system to run, what it is, if engaged in according to a formula, and we keep giving that formula: systematic, cooperative, sustainable, and equitable, and not imposed, can actually be the basis for creating new standards. We now have a whole series of what are called ISO standards, international standards of manufacturing, that actually, they don't only deal with the quality of the good manufactured, but the extent to which it is environmentally sound. They've opened up a whole new world where the negotiation of international standards can actually become a basis for global agreement. Another example was the Helsinki Agreement, which, when the Helsinki Agreement was drawn up, actually had the effect of creating a new consensus in the world about what were the basic abilities of people to demand certain rights and to assert that they could appeal those rights, to have someone they could appeal those rights to. Something very different, and especially different that it applied to the nations that signed it from what existed in many of those nations ahead of time. So what's the problem? Well, what really seems to be one of the major problems is that law is playing this role of creating a new world, but the structures of law and its institutions, again, are the old ones. So it's still highly controlled by professionals, some of whom don't recognize the need for cooperation. So they go to countries and they write constitutions without consulting anyone in the country. There's the belief that you can impose past processes and don't have to come up with new processes. There's the belief that once you get the law in place, it will mechanically work and doesn't require actually education and adaptation. And there is not agreement that the legal laws are created in a systematic, cooperative, sustainable, and equitable fashion. Laws tend to be created in negotiations, particularly international law. They tend to still be interest-driven, and they tend to be driven by logic and not by emotion and empathy, which is the source of equity, meaning fairness. And that gets us to the final meaning of law for most people in the world, and that is law as justice. Law as reflecting what are their foundational principles, and what they wish to have is not to have a legal system that binds them, but a legal system that expresses out and helps guarantee them that which is most important